Hi, good evening. My name is Bonifacio Rosario. I'm very sorry, I'm very ill today, but I need to video my last course project on uh, my course, regulatory framework and legal issues in business. The case actually being presented is actually agreed the docket number GR number 136805 of January 28, 2000. Um, I would like to say excuse me if I coughed because I'm really have a very bad um, voice. Okay, anyway, um, the case is actually reviewed from the Supreme Court of the Philippines. It is lodged actually between Diesel Construction Company Incorporated as the petitioner and Jollibee against Jollibee Food Corporations as the respondent. In this case, it is actually filed against the Regional Trial Court of Makati, Branch 61, whereas the case, the petitioner issued for a recovery on extra escalated construction cost of amounting of 4.3 million, which allegedly incurred in the construction of building located in Batangas and in Calamba, which is owned by the respondent Jollibee Corporation. But for the alleged failure of the petitioner to complete these projects on time, while at the said, GFC counterclaimed that in its answer, recovery of damages and attorney's fees in the sum amount of 2.7 million. In the pre-trial, the parties agreed to reduce the issues to whether to prove DCCI completed the Calamba and Batangas projects on time, or whether DCCI was entitled to escalated construction costs. But when they presented it after the trial with the RDC of Makati registered its judgment on May 13, 1997, ruling that the CCI had completed both projects on time and was entitled to the escalated construction costs. The dispositive portion of the judgment reads that wherefore premises considered adjustment is hereby rendered that the petitioner as again respondent is hereby as one Calamba project to be paid, of course, the Batangas, and to pay the sum amount of 400,000 as the way of attorney's fees and to pay the cost of the suit. And then after that, contending the RDC failed to order the payment of the extra work done, still the CCI actually filed on July 14, 1997, a notice of appeal, and on July 7, it is a motion of execution pending appeal. In the said motion, it cited that the good, therefore, was actually stressed out for the payment of the damages of GFC. Okay, so it has a special order on December 4, 1997. The current trial court nevertheless allowed the execution of the petition pending appeal on the finding that DCI was, as a matter of right, entitled to the payment of the escalation of the costs incurred by the DCI. So the petitioner would pose a ban equivalent to 100%, 150% of the total amount of judgment. Okay, so then when it goes to the court appeals, the motions, the court appeals actually rules out that it's a sealed resolution September 21, 1998, directed by the RDT is to issue the rate of execution upon petitioner's posting of 10 million bond and to stay execution upon its respondents filing the office's amount of 15 million. So DCCI filed a motion for the reconsiderations of this resolution insofar as it's allowed to stay execution, which motion of the Supreme Court, I know, not the Supreme Court, sorry, the Court of Appeals denied for lack of merit in the question resolution of December 22, 1998. What are the rulings of the Court Appeals is that the respondents first address the motion stay in execution is considered as premature. Okay, so it has not yet posted the required. Secondly, the time being petitioned of the motion issuance of premature writ of execution dated on July 28. When the CA was rejected the imputation of forum shopping, it held that when the petitioner posted the ban, the respondent could not file the trial court its own motion to post overseas bans since the records had already been elevated to the Court of Appeals. Since the petition, the issues was actually discussed in that memorandum, the petitioner raises the following questions: whether or not under section 3 of the Rule of Court of 39, appellate of court, like the Honorable Court of Appeals, has discretionary power to stay in the discretionary execution issued by the trial court. Whether or not a party in those favor is discretionary execution is issued may be stopped by attendant circumstances from assailing of the lack of authority, discretionary power of the appellate court, or stay in discretionary execution of the court. So to tap it all, so with the Court of Appeals actually issued the court of with no reasons to grant the execution pending appeal. The first issues of the ruling is the interlocutory orders, and of course, followed by the second issue is the discretionary restriction. The third one is discretionary execution pending appeal. And the fourth one is forum shopping. So the last actually was the Supreme Court found out of this findings from the regional trial court, which actually give the information and actually favored to the petitioner for the payment of what are the claims and the counterclaims of all the long procedures of our justice system, when therefore that the rule of courts say it in order to stay in this occasion, pending appeal should be good reason. So DDCI alleged financial stress by itself, it's not compelling reason in order to immediate execution. On the other hand, mere filing of GFC of a supersedeas fund does not automatically entitle it to a stay of execution. Wherefore, the assailed resolution set aside by the court, finds no good reasons to grant extraordinary execution in the context of the present of the case. No pronouncement as the cause, and that's so ordered actually by the Supreme Court. Okay, by Justices Melo, Vito, Purisima, Gonzaga, Reyes, JJ, and to concur. So in this case, the case was actually very informative. It shows that when you actually go into a business contract, into an agreement to fulfill both sides of the business, so in order to have no headaches of problem creating criminal costs or criminal cases or civil cases instead, so we should be going to abide with the regulatory framework and business legal issues in the Philippines or not in the Philippines, just to ensure that we are abiding the rules. Thank you.